Muchas gracias, profesora. Bueno, el presidente del Tribunal Constitucional, don Carlos Carmona, le va a hacer entrega de una medalla de reconocimiento por su ponencia y su participación en esta conferencia. A continuación, seguimos con la catedrática de Derecho Constitucional y miembro de la Comisión de Venecia en representación de la República Checa, señora Verónica Vilkova. Ella es miembro desde el año 2010 de la Comisión Europea para la Democracia por el Derecho, conocida como Comisión de Venecia. Es profesora del Departamento de Derecho Internacional de la Facultad de Derecho de la Universidad Carolina de Praga e investigadora en el Instituto de Relaciones Internacionales de la misma ciudad.
Not only. And then this and this. Okay. Good morning, Excellencies, ladies and gentlemen, dear colleagues. It is a real honor for me to be here to take part in this conference. I'm also quite pleased that this conference takes place in Santiago de Chile, because despite the distance between the Czech Republic and Chile, there is a certain link between the two countries. A famous Chilean author, Pablo Neruda, took his pseudonym, as some of you might know, from a Czech 19th century writer, Jan Neruda. So when in 1971, Pablo Neruda was awarded the Nobel Prize, the Czech people felt as if at least a small part of this prize went also to the Czech Republic. I have been asked to deal with the case law of the European Court of Human Rights on persons with disabilities, and actually it's quite appropriate to deal with this topic today, provided that 2 days ago, on the 3rd of December, we celebrated the International Day of Persons with Disabilities, so this panel could be considered a small birthday present for persons with disabilities. In my presentation, I will proceed in 2 steps. In the first part, I will give you a general overview of the case law of the European Court relating to persons with disabilities. And then in the second part, I will seek to identify certain features which characterize the approach of the European Court in this area. Let me stress from the outset that the European Convention does not contain any specific provision which would relate to persons with disabilities or to the concept of disability. In that, it refers not only from the UN Convention on the Rights of Persons with Disabilities, but also from the Charter of Fundamental Rights of the European Union, which is binding upon the 28 members of the European Union. This charter contains a very interesting provision, Article 26, which reads as follows, I quote, "The Union recognizes and respects the right of persons with disabilities to benefit from measures designed to ensure their independence, social and occupational integration, and participation in the life of the community." No such provision appears in the European Convention, which means that the whole system of the protection of persons with disabilities under the European Convention has been construed through the case law of the European Court. That is why this case law is so important. And then brings me to the first part of my presentation, in which I will give you a short overview of this case law. Just move this, yeah. Now, this case law reveals 3 main features. It's relatively recent, rather rich, and quite diverse. It's relatively recent because most of the relevant cases have been adopted over the past 5 to 10 years. It's rather rich because it encompasses more than 100 cases compared to the 4 cases which has just been invoked with respect to the American Convention. Don't be afraid, I will not be introducing all these 100-something cases. I'll just stick to 5 of them, as you can see in my presentation. And finally, it's quite diverse, reflecting the different difficulties that persons with disabilities face in their life due to their vulnerable condition. Despite that diversity of the case law, we can classify the cases into 3 main categories, which you can see in the presentation. The first category encompasses cases involving differentiated treatment of persons with disabilities. The second category includes cases relating to positive obligations on states with respect to persons with disabilities. And finally, we have the other cases. That means everything which does not fall under the first or the second category. This last category is again quite heterogeneous. It includes cases relating, for instance, to the origin of the disability or to social benefits accorded to persons with disabilities. I will not discuss this category. I will only focus on the first and the second category, always giving you some examples of the cases falling under these 2 categories. So first of all, we have several dozens of cases which involve differentiated treatment. That means cases in which persons with disabilities were denied, due to their vulnerable condition, the access to certain services or the enjoyment of certain rights. The European Court has dealt with these cases in 2 different ways, treating them either on the one hand as instances of discrimination, or on the other hand, as instances of a violation of one of the substantive rights protected by the European Convention. The concept of discrimination under the European Convention was covered by some of the previous speakers, but I will still recall the main principles applicable here. The principle of non-discrimination is enshrined in the European system in 2 spaces or in 2 places. In Article 14 of the Convention, and then in Article 1 of Protocol 12 to this Convention. The Convention dates from 1950, the Protocol from 2000. The 2 provisions are almost identical in their wording. The difference is that while Article 14 can only be invoked in conjunction with one or several substantive rights protected by the Convention, Protocol 12 actually contains a self-standing prohibition of discrimination. Yet, so far, the European Court has not decided a single case on persons with disabilities under Protocol 12. So all the relevant case law we have relates to Article 14 of the European Convention. There are dozens of cases relating to this area, out of which I will only invoke 2. Glor versus Switzerland from 2009 and Kukin versus Russia from 2011. So the first case, Glor versus Switzerland, the applicant was a Swiss national who suffered from diabetes, and he was declared unfit for military service because of that. Yet, since his minority was considered to be a minor one, since his disability was considered to be a minor one, that means under 40%, he had to pay a special tax, unlike a person suffering of major disability, over 40%. At the same time, unlike so-called conscientious objectors, he could not do a military service in an alternative way. There was no alternative offered to him. He considered this treatment discriminatory and turned to the European Court. And the European Court agreed with him, concluding that the Swiss authorities failed to strike a right balance or a fair balance between the protection of the interests of the community and the rights of the applicant. So there was a discrimination. The second case, Kukin versus Russia, the applicant was an Uzbek citizen who was married to a Russian woman. And he was denied the extension of his residence permit in Russia due to the fact that he was HIV positive. The interesting thing is that Russia did not introduce any similar measures with respect to its own citizens who were HIV positive or with respect to foreigners HIV positive coming to Russia. Again, Mr. Kukin appealed to the European Court, and the European Court, in what is, I think, quite an interesting quote, first found, I quote, that a distinction made on account of one's health status, including such conditions as HIV infection, should be covered either as a form of disability or, alongside with it, by the term other status in the text of Article 14 of the Convention. Yeah. Then the European Court concluded that this provision was, in fact, violated by Russia because Russia did not provide any compelling reasons justifying why it treated Mr. Kukin and the applicants in the similar situation differently from other HIV-positive persons. So much for the classical discrimination cases. Then we have some cases which also involve differentiated treatment of persons with disabilities, but which the court has decided not to treat as an instance of discrimination, but rather to treat them as an instance of a violation of one of the substantive rights. Most of these cases relate to Article 5 or Article 6 of the European Convention. That means the right to freedom and liberty, liberty and security, and the right to a fair trial. The most famous case of this category, however, relates to the right to vote. That's the Alajos Kiss versus Hungary from 2010. Mr. Kiss was a Hungarian citizen. He had mental problems, and he was placed under partial guardianship. Due to that, he could not take part in the elections to the parliament. He was denied the right to vote because under the Hungarian constitution, the right to vote is denied to persons placed under guardianship, even a partial one. Mr. Kukin did not like the situation. He appealed to the European Court of Human Rights, invoking Article 14, that means discrimination, and Article 3 of Protocol 1, which means the right to vote. Surprisingly enough, the European Court decided not to discuss this case under the provision on discrimination, and it solely focused on it and solely discussed it under Article 3 of Protocol 1, that means the right to vote. And it concluded that this right was indeed violated, and that Mr. Kiss's right to vote was violated because the denial of the right to vote for those placed under guardianship was a blanket automatic measure which did not allow to take into account the specific position of each and every particular applicant, including Mr. Kiss. So much for the cases of the first category. And now I will briefly introduce the cases of the second category. That means the cases in which the European Court of Human Rights established that the member states of the Council of Europe had some positive obligations with respect to persons with disabilities. Again, we have dozens of such cases. However, a vast majority of these cases are quite similar to each other, and they relate to the positive obligation to take into account and accommodate the special needs of persons with disabilities when their liberty is limited. That means when they are in such institutions as, for instance, police custody, detention centers, hospitals, or psychiatric centers. The paradigmatic case of this group is the case Center of Legal Resources on behalf of Valentin Campeanu versus Romania, a Grand Chamber decision of 2014. The applicant here was a young man of a Roma origin who was severely mentally disabled and, moreover, who was HIV positive. That's as bad as you can get in Central and Eastern Europe. So he had all these three forms of disabilities. He was placed to a psychiatric hospital and he died there. And the European Court concluded that his death was to a large extent attributable to Romania and to the failure on behalf of Romania to, I quote, demonstrate special care in guaranteeing such conditions as correspond to special needs resulting from the disability of the applicant. So there was a violation of Article 2 of the European Convention of the applicant. That means the right to life because the person died in this psychiatric place. As I already mentioned, a vast majority of cases falling under this second category are quite similar to this Campeanu versus Romania case. we have a tiny minority of cases in which the European Court declared the presence or the existence of other positive obligations. And a typical case of this subcategory is Djordjevic versus Croatia, a case from 2012. The applicants here were a mother and her son. The son was both mentally and physically disabled. And these two people were, over a very extensive period of 4 years, harassed by members of another vulnerable group, which will follow, that means children living in the neighborhood. They complained to the European Court, and the European Court concluded that there was a violation of human rights because the Croatian police knew about what was going on, but it did not take any measures to protect these two people. So the the European Court concluded that Croatia failed in its positive obligation to protect the applicants from the violent behavior of the children involved, and it found a violation of Articles 3 and 8, that means the prohibition of inhuman and degrading treatment and the right to private and family life. That brings me to the end of this short overview of the case law of the European Court on Human Rights on persons of disabilities. As you can see, this case law is really quite rich. It's richer than the one on the Inter-American Court. And now in the second part, I would like to identify certain characteristic features that I see, that I can detect in the approach of the European Court. I already said at the beginning of my presentation that this case law is recent, rich, and diverse. And I hope I have managed to demonstrate it throughout my presentation, so I will not go back to these 3 points. Rather, I will focus on 5 other points, and I will be rather brief on all of them. So first of all, the first conclusion. It's quite clear from the case law of the European Court of Human Rights that persons with disabilities are seen by the European Court of Human Rights not only as persons enjoying the protection of the Convention as any other individuals who find himself or herself within the jurisdiction of one of the Council of Europe country, thus, but also as members of a particular group, that of disabled person, which deserves special protection due to its vulnerability. So that means that despite the silence of the European Convention on the concept of disability and on persons of disabilities, there is actually a system of protection of persons with disabilities in Europe under the European Convention of Human Rights. It's also quite clear that this group is considered as a special group within the broader group of vulnerable persons, which explains why we deal with this topic today here. That's the first characteristic feature. Secondly, the European Court is obviously called upon to apply the European Convention. That's its task, that's for sure. Despite that, it does not ignore a broader normative framework which has been put to place to protect persons with disabilities. Starting from the Glora case, 2009, the European Court has repeatedly and systematically referred both to the UN Convention on the Rights of Persons with Disabilities and also to various soft law instruments on persons with disabilities which have been adopted within the Council of Europe. More than that, it has also used certain concepts which are quite similar to those we find in the UN Convention. For instance, the concept of reasonable accommodation. As far as I know, the European Court has not so far referred to the American Convention or to the case law of the Inter-American Court. But since we have some judges of the European Court present here in this conference, maybe there will be a change after this conference in this respect. That's the second point. Third, while the European Court refers to the concept of disability again and again, it has not so far produced any definition of the concept of disability. In this, however, it is not alone, because even the UN Convention on the Rights of Persons of Disabilities failed to define the concept of disability. And this omission is a deliberate, intentional one, because as the preamble to the UN Convention declares, I quote, disability is an evolving concept. This view is shared by the European Court, and it actually sits very well with the idea of the European Convention being a living instrument which must be interpreted in the light of present-day conditions. So no definition of disability. Despite the lack of the definition, it's quite clear that the European Court has quite a broad understanding of the concept of disability as a concept encompassing both mental and physical forms of disability, both major and minor forms of disability, and going so far as to qualifying as a form of disability the position of HIV positive persons. So it's quite a broad conception of disability. At the same time, the European Court leaves it up to the case-by-case assessment to decide whether a certain applicant is really within this group of particularly protected persons or not. That's the third feature. Up to now, I have been rather positive about the European Court of Human Rights. Now I will be more critical in my last two characteristic features, in my last two comments. And these last two comments are actually critical comments with respect to the treatment by the European Court of Human Rights of these two categories of cases that I invoked in the first part of my presentation. So the first critical comment, number 4, goes to the first group of cases that I identified, that means those relating to the instances of differentiated treatment. We saw that sometimes the cases of differentiated treatment were treated as instances of discrimination. In other cases, the court found a violation of a substantive right. And it's not clear from the jurisprudence what makes the court opt for the first or the second approach. One might think that probably the suggestion of the applicant is behind, but that's not the case. As we saw in Alajos case versus Hungary, the court is actually very happy to disregard the position of the applicant when it finds it appropriate. Yet we don't know what makes the court find it appropriate to opt for this or that option. It might seem that in the end it's not really important whether the court establishes discrimination or violation of a substantive right. But since the standard of proof is not necessarily the same under these different provisions, opting for one or the other way can actually decrease or increase the chance of the applicant to succeed with his case. So that's my reproach or my critical remark towards the treatment of the first category of cases. And then my second remark goes to the treatment of the second category of cases. That means those relating to the positive obligations. We saw that the European Court of Human Rights, for instance, in this Valentin Campeanu case, was quite bold in establishing the existence of positive obligations of the states with respect to people whose liberty has been somehow restricted, people in prisons or in hospitals. At the same time, the European Court has been rather unbold or rather reluctant to establish the existence of other positive obligations of the states with respect to persons with disabilities. We only have really a couple of cases which would be about other positive obligations. Now, most scholars believe that the reason behind is the fact that actually establishing these or finding these, declaring the existence of these positive obligations could have important budgetary implications, and that it could somehow blur the distinction between the first and the second generation of human rights, going too much into the social or economic sphere. That might be true, partly, but despite that, I believe that especially when dealing with cases relating to such a vulnerable group, the court should think a bit out of the box and really look for ways and measures which efficiently protect human rights of these vulnerable people. Now, I would like to end my presentation in the same way as I started it. That means by invoking Pablo Neruda again. Pablo Neruda wrote something that I find not only very touching as a person, but also very relevant for the topic of this seminar. So let me quote Pablo Neruda. They have the Spanish text, so don't forget it. Don't be afraid that will be a correct translation. So I quote, "There is no insurmountable solitude. All paths lead to the same goal, to convey to others who we are. And we must pass through solitude and difficulty, isolation and silence, in order to reach forth to the enchanted place where we can dance our clumsy dance and sing our sorrowful song. But in this dance, or in this song, there are fulfilled the most ancient rights of our conscience, in the awareness of being human and of believing in a common destiny." Now, I believe that peoples with disabilities often have this feeling of solitude and of isolation, which stems not only from their physical or mental handicap, but also from all the social prejudices which are linked to this. And I hope that the European Court of Human Rights, as well as the Inter-American Court of Human Rights and the different national courts, can help these people overcome their feeling, surmount solitude, and regain the belief in a single and undivided humanity to which, after all, people with disabilities, as well as members of other vulnerable groups, belong as much as anyone else. Thank you very much for your attention.